Hey, all persons having anything to do before the Honorable. The Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth, Masters. Court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. I am Chief Justice Amy Blake. To my right is Justice Suk-Young Shin. To my left is Justice Maureen Walsh. We are your panel for the 6 cases that are scheduled to be heard today. I know most of you have been here before, but just a few reminders. Each side is permitted 15 minutes of argument. There is no rebuttal. I know there are some time splits today, and we'll have some conversations about that when the cases doing that are called. I can assure you that we have read all of your materials, so you should get right to the substance of your argument. If your case is impounded or partially impounded, I will remind you of that, but please be mindful of that when you present your arguments. With that said, I will likely take a break after our 3rd case. It is possible that there'll be a 2nd break because of a technical issue with having to set up a hybrid remote oral argument, but I will advise you as we go along in that respect. The first case is Commonwealth versus Bernardo Seamus, docket number 24P360. Good morning, counsel.
Good morning, Your Honors. Zachary Lown for Mr. Seamus. May it please the court. The videotaped deposition in this case was inadmissible, and the Commonwealth's only witness stated unequivocally that she was not going to return to the United States. And had trial counsel objected to its admission, the Commonwealth could not have prosecuted the defendant. Instead, trial counsel's agreement to waive his client's rights and admit the video handed the Commonwealth its sole means by which to convict his client. And this was manifestly unreasonable. As I laid out in the brief, as Mr. Seamus laid out, the deposition failed in all aspects of presenting testimony in a way that was structurally fair and constitutionally sound. And the case law on this front was explicit, and it was not followed. Nearly every ill in Bergstrom was repeated in this case, and that included that the recording showed only JS's face. Neither the judge, prosecutor, defense attorney, nor Seamus were visible. The attorneys who were asking questions were heard as disembodied voices. The video did not show Seamus and JS in the same room together. The judge did not instruct the jury that it was to draw no adverse inferences against Seamus from JS's absence at trial. As stated in Commonwealth v. Johnson, furthermore, jurors who are not instructed to draw no adverse inferences from the seating arrangement may do just that. And in fact, the jurors were not even instructed that JS was testifying in the presence of the accused until after the video recording had concluded, when they were playing it at trial.
It seems like the primary issue with the video in Bergstrom was that there is no face-to-face confrontation. The witness was literally in a different room than the defendant. And we don't have that here. And my question is, how do you deal with the statement in Amaralt where the court said that ideally all persons present in the room would be visible in the video? It is not, however, a fatal flaw to an otherwise satisfactory videotape. Doesn't that suggest that having the video show everyone in the room is more a matter of best practice rather than a constitutional requirement?
Bergstrom's statement with regards to what is constitutionally required going forward was that the video, to the extent possible, must show the confrontation as it occurred. I think that in this situation, the question that we're dealing with is a substantial risk of miscarriage of justice, is prejudice. And I think.
But is there any case that finds that to be alone a constitutional violation?
Well, the cases that were cited, Bergstrom, Amaralt, Johnson, I think that what occurred here was a violation in and of itself, that it was in error, and that the error therefore caused prejudice. Whether it's a structural error that requires automatic reversal, I didn't advance that argument, but I think that the fact that they're not shown together, that it's not actually displaying the confrontation as it would take place, makes it structurally unfair and constitutionally unsound. And those guidelines that you mentioned, Your Honor, were laid down something like 20 years before this case took place. So I think that it goes to the question of error. I think that whether reversal is automatic may not be the case, but still it provides a depiction that is fundamentally unfair. And I think that some of the commentary also in Amaralt itself to the effect that the camera isn't just showing a two-dimensional, or rather a sort of exact replay of what happened, but it's actually choosing its focus. It's necessarily commenting on what's happening, as any movie director or television director might conclude. It's actually showing the juror's perspective for them. And in this case, what counsel, I think the law is clear that the way it was structured in and of itself was fundamentally flawed, and that the videotape should have been excluded and was inadmissible, and that if counsel had moved on those grounds or had been aware of that case law, he could have effectively excluded it, and that it should have been excluded.
Can I ask you a different question?
Yes.
What do we have in the record that counsel learned after the deposition that would have made a meaningful difference in the cross-examination of her at trial?
Nothing. The reason why we have nothing in the record is because there was our request for an evidentiary hearing was denied. Trial counsel, as
do we have an offer of proof from trial counsel about what he had hoped to do on cross-examination?
I was not able to secure that, Your Honor. We did ask for an evidentiary hearing. He did admit in a pleading that he had done additional investigation, and of that, we have no further information.
So you're arguing ineffective assistance, but you're also claiming that the judge erred in admitting the video at all, right?
Both sides of the equation.
So
yes.
if defense counsel agreed to the admission of the video, how would it be an abuse of discretion on the part of the judge to admit it?
I think that the trial court had an independent responsibility to ensure that he is presiding over a fair trial, and that the evidence which is presented is competent and...
But if trial counsel makes a strategic decision that he believed was in the best interests of his client, how could the judge sort of overrule that decision?
Well, trial counsel can't admit or ask for inadmissible evidence. Trial counsel, or rather the judge, could exclude that as well. I wouldn't say that's my...
Can I interrupt for a
Yes.
moment? I'm having a hard time following that argument. So in other words, if a trial counsel decides to allow an admission in, now, the judge might think, that's interesting. But that's trial counsel's decision, if it's strategically based and not ineffective, because there may be some other value in introducing that evidence or some other strategy. So where this was agreed to by trial counsel.
Yes.
We can still find, you're suggesting, an abuse of discretion by the judge in not allowing that in.
So I would say that my attack here is not so much on the judge making a game time decision to admit something which the defense is the proponent of, and then later claims objection to. I would say my thrust of the argument is focused on the tactical, manifestly unreasonableness of trial counsel to ask that this video, or essentially to waive in the sole means, as I pointed out, by which the Commonwealth had to convict his client. So I'm not wedding myself necessarily to your point. I could see, being in the judge's shoes and, perhaps it's an abuse of discretion, perhaps not. I don't think the case rise and falls on that point because, as stated, with JS said unequivocally, she's not coming back for trial. Counsel has a video, which I argue is inadmissible, and to your point, Justice Shin, if the video is admissible, then I think I lose this argument. But if the video is not admissible, which I strongly argue that it was not, trial counsel had no practical benefit to agree to admission of a video of a crying victim, the camera zoomed in solely on her face with no ability of the jury to actually assess the confrontation and give Semmis some of that attention and credit he might
Except
otherwise.
he says he had information that led him to believe she would appear for trial.
I think that's really contradicted by the record, Your Honor. I think that
you make a somewhat contradictory argument that the Commonwealth didn't prove she was unavailable. I mean, we really don't know on this record whether she would have appeared or not, right?
The record is her saying that she's not coming back. What should have happened was.
Well, but wait a minute. At RA 176, trial counsel under the pains and penalties of perjury says,
Yes.
after speaking with the prosecutor, quote, "If we insisted on the witness's presence, she would have indeed come back, and she would provide compelling testimony." To me, that speaks volumes as to the strategic decision that trial counsel made. That's uncontroverted in the record.
I would argue that it's controverted, Your Honor, by what the prosecution says, which is that.
In response to the affidavit?
The prosecution goes on. Well, the prosecution didn't have the opportunity to respond to this affidavit, which is submitted post-conviction. Again, I would have liked the opportunity to cross-examine trial counsel on that, but the prosecution does go on the record also under penalties of perjury stating that JS is financially, the whole litany of things which she lists, dependent on her parents, is not coming back, has just graduated, I think it was, or is entering college, something to that effect, has no plans to return to the United States. That was, the prosecutor submitted that affidavit twice. And so what should have happened was trial counsel should have moved to exclude it. The court could have given the Commonwealth 30 days or whatever period of time to get JS to come to trial using all of the steps that some of that case law suggests or prescribes, and she doesn't come and the case is dismissed. We don't know whether, that was the record, that she was not coming back.
I'm just going to disagree with you on what the record says, and it's not a situation where reasonable minds can disagree about theory. I think the record is clear that the prosecutor admitted that there were difficulties with this particular victim, and there were some hurdles to get over. But even defense counsel admits that if she came in, it was going to be a much more difficult case for him to defend. Everybody seems to agree on that except for you, counsel. That's the way that the case unfolded. And so it makes the manifestly unreasonable argument difficult. I know it's your job to present difficult facts, but the facts don't seem to be, in any reading, to be other than that.
Yeah, I think that trial counsel's self-serving statement, as we often use that term in regards to defendants, that to justify his actions after the fact is what he agreed to, again, was the admission of a video that was fundamentally unfair, that is a video of a crying victim, that it's only zoomed in on her face and eyes, that there's no way for the jury to view this confrontation, that he has a confrontation which is not a confrontation at all, but something which is fundamentally unfair, and that if he had objected to it, she does not return, the case is ultimately dismissed. So I think that that is, or that the case cannot be prosecuted. So the question is one of whether it was manifestly unreasonable for him to agree at that stage in the proceeding to simply waive this into trial. And again, I think that's something I could cross-examine him on, but I couldn't see how the testimony could get worse. At the very least, it would be more fair in terms of I'm referring to the setup or the scenario in which that the jury would have an opportunity to view the full picture. And, lastly, I just wanted to say that the case turns on, that it does turn on, to go to whether this was prejudicial, to go to that argument, that the case turns on credibility in the absence of any other eyewitness or corroborating evidence. I think that there were fair arguments in terms of how Semmis can be interpreted, the testimony that he provided and did not waver from on cross-examination, and that given that this was a credibility contest, it's reasonable to conclude that the error might have swayed the outcome.
And we will have to leave it there. Thank you, counsel.
Thank you.
Attorney Morse.
May it please the court, ADA Bryn Morse on behalf of the Commonwealth. With me at counsel table is the trial counsel, Casey Sherman. So I'm going to start with the confrontation clause issue because I think that goes to the crux of the case. If the video deposition was admissible, if the witness was unavailable, then it substantially changes the ineffective assistance of counsel claim. So here the confrontation between the victim and the defendant was enough for it to be properly admitted under the confrontation clause. As both Tufts and Amaral say.
What do you mean by enough? What is that quantum?
So in this case, it's really just that the victim and defendant can see each other when the actual confrontation, when the testimony takes place, and that happened here. That's the constitutional requirement.
But counsel, I mean, he has a point in terms of what this looked like for the jury. Whether or not that rises to a constitutional challenge, I think, is a different question. But would you concede that if you had to do it over again, maybe you would have set it up a little bit differently?
So, Your Honor, I'm actually not sure what camera angle the court was suggesting in Bernstrom when they said include everybody in the picture. I mean, the most important thing is that the jury can see the testifying witness clearly and gauge her reactions, and that happened here. Bernstrom talks about like being able to see everyone in the courtroom, and then it suggests, I believe it suggests that like maybe it's enough to just tell the jury that everyone's in the courtroom.
Or periodically, the camera angle can change and show who's in the room. I mean, Tufts says that in the future, judges who have the benefit of Bergstrom should make sure that the video shows everyone present in the room.
So my concern with that, Your Honor, is if the video is shifting around, then it's not showing the witness all the time. It's actually suggesting to the jury where they should be looking. I mean, I'm not quite...
You could pan to the defendant while the prosecutor is posing a question to the victim. I mean, today's technology...
It could do that, but the victim's reactions while questions are being posed, I would say is actually like critical facial reactions to the juror's assessment of the victim's credibility. All that is to say is that when you make a choice to include other people in the video, you necessarily lose a different angle, or you have multiple people on the screen at once, and then you don't see the victim or the testifying witness as clearly.
I mean, I'm not sure that we have to live and die in this position, since I don't know that any of us are videographers, right? But the point being is that this is a very unusual kind of procedure that occurs. And so with that would be the safeguards that the best that we can protect knowing that it's different, video cam versus live, but if you're in a jury box and you're looking at a witness who is testifying, and there's the defendant right there, the jury is able to move their head and look and see everything. And I think to the extent that possible, that a video camera can somewhat capture that essence. Can you agree it's not a bad idea?
Done perfectly, it might not be. Here, though, there were also, there were substantial other things that made this, shall we say, a good practices deposition. The jury were informed before it was played that it happened in a courtroom. They were told that depositions happen in a courtroom, which that might not be accurate, but here it was. There was clear voices, a clear video. You could tell based on the voices who was speaking, whether it was the prosecutor, the defense attorney, the judge, or the clerk. And you could actually briefly see both the prosecutor and the defense attorney when they approached the witness. And in addition to that, the victim ID'd the defendant during the deposition, pointing him out in the courtroom. And so it was clear to the jury that the defendant was, in fact, present throughout this entire deposition. And so from that, the deposition was enough under the confrontation clause for it to be admitted if the witness was unavailable. And let's second move to the question of unavailability. So it's a little unclear under Hunt whether the victim could be considered unavailable here. Because in Hunt, the Commonwealth also didn't offer to pay for the testifying witnesses' travel and lodging, just like happened here. In Hunt, there was maybe a little clearer of a statement that the victim or the testifying witness was not willing to return or did not want to return, I guess was the language used there. Whereas here, we had that the victim didn't have any plans to return to the United States, as well as a listing of some circumstances that would make it difficult for her to return to the United States. So under Hunt, she may be unavailable under these facts, and that's the Commonwealth's position. But in any event, if she wasn't unavailable based on that record, then had the defendant actually continued to push back on her unavailability and not allowed the admission of the deposition, then it's one question to the victim, are you willing to come or not, that would establish her unavailability. And if she's willing to come, then she testifies in person at trial, and that's far worse for the defendant. And if she's not willing to come at that stage, then she becomes unavailable definitively, and the deposition is admissible. So what trial counsel really faced in his strategic decision here is, does he push for the victim to potentially be unavailable and the deposition's admissible, or does he push for or maybe the victim is available and then he has to deal with the victim actually coming out to trial? And that would substantially damage his defense here, that I would say is a good one. His defense was based off of the fact that the victim...
Consent, right? The defense was consent.
The defense was consent, but the shall we say, strength of his defense was based off of the victim's mannerisms during the deposition, right? And that's something that the defendant couldn't anticipate would necessarily be the same a while later at trial. And also, with the deposition, he knew exactly what her testimony was going to be, how it was going to be limited, and that gave him a lot of ability to kind of project how the trial was going to go. And that's a reasonable strategic decision.
So let's say it was quite clear that the witness was unavailable and would not come back. Would it then be ineffective not to object to the admission of the video?
I don't think it would be ineffective here where we have multiple cases saying it's not a fatal flaw for just the victim to be on camera. I think that the case law is clear this gets admitted.
Well, but there's a difference between she's unavailable and he agrees to have it come in versus looking to have the case dismissed, right?
So
I think you make that distinction in a footnote in your brief.
So
I know you didn't author the brief, so I will take that back.
Even if the case were to be dismissed at a particular time, it's dismissed without prejudice. It just means it can be recalled anytime the victim decides to come in. I'll also note that legal unavailability and it's totally impossible that the victim will ever come back to testify are two different things. So legal unavailability is a lower standard where we can simply get that by the victim saying, I don't want to come back. And actual unavailability is more the situation where, you know, the victim is told if you don't come back, nothing happens in this case, right? And they still don't come back. But I think setting that aside, the strategic decision that trial counsel was making is to get what he expected, I think reasonably, to be substantially weaker testimony than live in-person testimony. And he said in his affidavit he expected that the victim was going to return. And sure, he can't guarantee that, but it was a reasonable strategic decision based off the information he had at the time. If there are no further questions.
I don't see any. We will take the rest of your argument on your brief. Counsel, thank you both very much. This case is now under advisement. Mr. Guarino, that's fine. Our next case is Commonwealth versus Christopher Clayton, docket number 24P812. This case is partially impounded. Mr. Bogosian.
Excuse me, Arne Hansen for the Commonwealth.
I'm sorry, first we have the Commonwealth. I apologize for that.
Thank you, Your Honor. If it pleases the
Mr.
court.
Hansen.
Arne Hansen for the Commonwealth, representing the Plymouth County DA's office. Today, we ask that this court vacate the trial court's decision on the motion to suppress. As you know, there was a search warrant executed at a specific location because that location had been linked to dissemination of child pornography.
Can I ask you to deal with something that I hope is quick to deal with, which is opposing counsel makes the argument that what you are arguing on appeal is not what the judge actually ruled. And do you agree? And does it matter?
I actually do agree with Attorney Bogosian's assessment of the situation. It's not whether a second search warrant was needed in this case. It's whether there was probable cause within the search warrant. I think Judge Sharkansky makes very clear in the motion to reconsider transcript that it's not about a second search warrant. So we're just challenging his decision regarding probable cause within the original search warrant.
Search of the phone.
Correct.
Okay.
So to put it succinctly, I think the argument here is that the judge applied the wrong standard of or analysis in this case. I think Martinez and Molina are two cases that are very much on point that make very clear when you find that child pornography is being disseminated through a certain IP address and that IP address is linked to a specific home, which was the case in here.
Okay, but Martinez and, let me interrupt because we have such a limited period of time. Martinez and Molina, if you agree, were really whether or not kind of this box, this house could be searched because of the evidence. And the argument was it's not enough just to have an IP address. And the court went through and said, it is, right?
Right.
Okay. This is different, isn't it? So, in other words, the defendant isn't challenging necessarily, although he is, the search. For a moment, it's not about the search of the home itself. It's about the search of Mr. Clayton's person and grabbing the phone. So does that matter? In other words, if they have probable cause to search any place in the home, does it matter whether the phone was on top of a desk, in his pocket, in a trash barrel?
No, because Molina makes very clear that you can grab and seize and search any digital devices that are maintained within that home. So in Molina, what happened was that defendant is at the location, admits to having the child porn. They see an open computer that is disseminating child porn as they execute the search warrant. They took that computer, but the court still held that they are allowed to take every single device within that apartment, and they took an additional 11 or 12 devices, that, despite the fact that they knew the defendant's computer was disseminating this information. They still had a right to take everything else. They didn't need to specify, we're taking this individual's phone because we have information that this individual is the one that is disseminating this.
So in Molina and Martinez, they knew, in essence, who the person was.
I don't believe that was the case. So in Martinez, they didn't know who it was. They didn't even have any information regarding the defendant. And then in Molina, there was 5 people that lived at that location, and they didn't know which of the 5. And in both cases, there's an identified individual attached to the IP address that has the contract for the internet. Neither of those individuals were the named defendants in those cases.
So you don't think it makes a difference as when the police went to search the home, whether the phone was just out on a desk or in his pocket? Because it seems to me that what the defendant is relying upon is the all persons present and the specificity of connecting probable cause to a person versus probable cause to search evidence of a crime in a location.
Correct. So I think the Martinez and Molina cases make very clear if there's a digital device that is capable of transmitting this type of information, child pornography, you are allowed to seize and search that device. You don't need to link it to a specific individual. Anything within the 4 corners of that apartment can be searched and seized.
Whether it's on a person, in plain view, anything.
Correct.
But what's the distinction as a doctrinal matter with the all persons present cases, which say that in order for that to be valid, you have to have probable cause or suspicion that all the persons present are involved in the criminal activity? Like, how do we reconcile those 2 lines of cases?
So I think here there was additional information that this individual, the defendant, was actually the one that was transmitting the child pornography.
Right, so if the warrant had been limited to a search of the defendant's person, that would be different, but it says all persons present. Is that literally all persons present, including the children who are present? Is that how you read the warrant?
Yes, because there was 7 individuals that were potentially living at that home. The police don't know exactly who that is, and they don't have to know who it is.
So it doesn't matter that there was more information linking the defendant to the criminal activity, right? Because we have to assess whether the all persons present provision is valid on its face.
I think that's fair.
Okay.
But I would point out that and something I think the trial court didn't consider, is that there was additional evidence here. So on page 7 of the search warrant, 7 and 8, it shows that there's 3 files being disseminated. And these files are child pornography. The names of the files are Chris, which is the defendant's first name, _ and then a series of numbers and letters that don't necessarily mean anything, or at least not in the English language. So that, again, suggests that the defendant was the one disseminating this material. He's the only person named Chris at that location. And then there's additional evidence on the next page, on page 8, where the username associated with this information or spreading this information was Chris Apple. Again, defendant's first name. He's the only individual.
But again, how does that go to the validity of the all persons present provision? And maybe it does. I'm just not seeing.
I think the Martinez and Molina cases make very clear that the issue is we're focusing on the devices, and it doesn't matter who's in possession of the devices, because you need to link the location to be searched with the items to be searched, or not the people.
So 2 different theories. I'm just trying to make sure I understand your argument, because I also noticed at the hearing, the prosecutor made a different argument too, right? And we're talking about the 4 corners of the affidavit. Because, frankly, I'm not even sure how we get to where the phone was located without a hearing. That it was on the defendant's person?
That is my understanding.
There was no
hearing.
No facts, and there was no testimony from a witness about where the phone was located. You're saying as a matter of law, let me switch it up. Let's say the search warrant and the clerk magistrate didn't check off all persons present, right? They say you're authorized to search the property on Front Street for any evidence, digital, otherwise it could store child pornography.
Right.
Your position, if I understand it, is as a matter of law, under Molina and Martinez, that they could seize and search the defendant's phone because it was capable of storing child pornography.
Correct, and I think that's what Molina makes very clear.
So whether or not the all persons present argument lives or dies, right? Whether it was overly broad, whether or not there's probable cause for all persons present to believe they're committing crime, your position is, as a matter of law, because it was a search of a residence, they could search anywhere and anything that could contain digital storage of child pornography, period.
Yes. If the court has no further questions, I would rest on my brief.
Let me just check. I see no further questions. Thank you.
Thank you.
Now it's Mr. Bogosian's turn.
Thank you very much. Paul Bogosian on behalf of Mr. Clayton. I think that the court's questions are pointed in exactly where we are. If you look at the face sheet to the search warrant, the face sheet to the search warrant adequately describes the property to be searched, the physical location of the property where the house is located. It then indicates who it's occupied by or in the possession of. And then the next box on the person or in the possession of is not checked off. It's blank. And then it jumps to an any person present warrant, and that's checked off.
Okay, so if we ignore the any person present for a moment, just for a moment, because we're going to give you an opportunity to make
Sure.
that argument, you agree that this is a search of a property,
Yes.
not of a person associated with the property. That's what the police asked for, to search this particular address on Front Street.
They ask for that, but they do beyond that.
So this is what they asked for, this is what they got. So I just happen to have my phone. They search, and they walk into the house, and lo and behold, there's a phone right there. Can they take it?
I think pursuant, and that's the discrepancy, that's the
Go ahead,
anomaly
but can
here.
they take that phone?
I think pursuant to the concept that in Molina and Martinez, the court announced, and that is that the Fourth Amendment protects people, not places.
Yep.
They utilize that concept to then support and
Yep.
bootstrap the argument and say, you know what?
Computer now.
Everything that's found is okay.
Yep.
But
Take both?
according to Molina and Martinez,
Okay.
yes. However, Molina and Martinez, it is very clear, are premises search warrants. They're not person search warrants.
This is a premise search warrant.
This is a premises search.
Now, they have information about potential people who live in that, as most search warrants do, but follow me for a moment. So I got a computer here, I got a phone here, police come in to execute this search warrant. Can they grab it?
Yes, according to the
Okay, can
case
they
law.
search it?
Yes, according to the
Okay.
case law.
Here we go. Phone is in here.
Yes.
Can they take it?
No.
Tell me why, because the prosecutor says that they can under Molina and Martinez, anywhere where evidence of a crime
Yes.
could be found,
Yes.
they can take. You tell me why they can't.
Because of the appeals court case of Commonwealth versus Brown, 68 Mass Appeals Court, 261, a 2007 case.
Brown also says in that all persons present in general that they weren't referring to the people who were occupying or residing. I mean, that was like for the Girl Scout cookie person who happens to walk in and an innocent bystander goes into a home and all of a sudden gets searched by police, right?
Are you referring to Brown? No, actually, Brown dealt with a narcotic.
No, I know Brown was in the Girl Scout cookie case.
Oh,
I'm
okay.
saying that that's the whole premise behind it, was the innocent bystander. And when they define what all persons present, they didn't generally have in mind the people who were occupying the place. It was really for the protection of those innocent people who just happened to be at a person's house while a search warrant was being executed, right?
Well, I think that's true, and I think it was for the pronouncement of the principle that our precedent establishes for an any person present warrant. And that is, you need probable cause to believe that more likely than not, everybody present on that premises is involved in the criminality. Here, you have child pornography, which even makes it even more, less so, much more less so, because to the extent that when they walk in, they find, on this case, they find 4 adults, they find 4 children ages 1, 3, 8, 15, and they also find a person who's not mentioned at all as occupying and or possessing the property. So what I'd liken it to is, at the time anyone's going to execute a search warrant, they walk in and there's a graduation party of 200 people present, are they allowed, merely because of Molina and Martinez, to then search everybody, even though they're standing outside? I provided a case by the Pennsylvania Supreme Court in which they addressed just this in the nature of a child pornography case. So the only difference that I see with Commonwealth versus Brown and what happened here is Brown deals with narcotics and the search for narcotics and an any person present warrant, versus here we have child pornography, and we have the 2 cases of Molina and Martinez that, again, are premises warrant cases.
Your position without the all persons present argument, though, just on the scope of a search, is that if it's on a person, on the defendant's person, versus generally anywhere hidden in the apartment or home.
I understand. It's an anomaly and it's a problem.
Right.
Because to actually parse that out, the only thing that I would say is this: to the extent that the Supreme Court parsed out that the Fourth Amendment protects people, not places, and utilized the places concept to support Molina and Martinez, what about the people? What about the privacy interests and intrusions that are actually occurring inside the house for people who are not within the probable cause aspect of an any person present warrant?
And your argument is that the police couldn't have seized the phone. You think the judge got it wrong on that first?
What I think is that because I challenged the any person present warrant, that there's precedent to say that there wasn't probable cause for the any person present, that because they didn't then check off also on the person of, that they didn't have a right to seize directly from the person. I would suggest, contrary to my brother's argument, that the only inference to Mr. Clayton was a very passing inference, and that is that they spoke to the local police, the state police, and they found that a person associated, quote unquote, with the residence was Mr. Clayton. There was no gravity to that statement. There was no qualification. They didn't see him coming and going. They ran RMV check, and the RMV check didn't show that he even lived at that address. That was omitted from the affidavit. They went
No,
and...
but we know what the standard of probable cause is, not to interrupt you, but,
Sure, no,
to
it's
interrupt you
okay.
for a moment. I mean, we know what the standard is,
Sure.
right? And so you've got Christopher_C. Your client is Christopher Clayton. And then you've got Christopher Apple. And you've got him associated with this residence. That's not probable cause?
If I may, there was not Christopher_C. It was Christopher_ and 4 or 5 numbers.
5191, right?
Then there was Chris Apple. When they went into the residence, there was nothing that indicated that he was living at that residence. There was nothing. There was no information whatsoever. So if we assess the calculus, the probable cause calculus, nothing said that he would be there. However, when the police went upstairs, they seized him in the house. They then asked him his name. When he indicated Chris, they thought that they had their man. Other than that, they didn't expect him to be there. His address was in another town. His car wasn't there at the time of execution of the search warrant. His mail was not going there. They checked the mailbox. There was nothing that said Christopher Clayton resided at that address.
So I'm just going to refer to the record appendix, page 91, and it's Christopher_C 5191.
Okay, I apologize.
It's okay,
My error.
but
My error.
there's a connection.
Okay, yes,
there, right?
it is,
And
unequivocally.
to know whether he lived there 5 days a week, 7 days a
Yes.
week. He's associated with this residence, and we've got Chris Apple, and we've got Chris_C 5191. They come upon, lo and behold, the only Chris connected with this apartment or home. That's not probable cause to believe that evidence of a crime will be in his phone?
I don't know if I can add suppose one of the children's names was Chris Jr. or Chris. Suppose the 15-year-old was Chris. Very interestingly, what they did in this case, they also exercised their own discretion. They didn't search, when they went in, they got the any person present warrant, but they didn't search the children, they didn't search the women.
Well, if you go under any person present, they still have to connect probable cause to the
Sure.
person. So
Sure,
they did
possibly.
the right thing by not.
Yeah. I think so, they exercised their discretion, but
Right.
irrespective.
Okay, so-
The only other thing that I would point out to the court that I also challenge, and I'll move on to my last argument unless the court has any questions, and that is a minimization protocol of Molina. Obviously, we talk about it in Commonwealth versus Snow, and that is there were no boundaries to the search of this telephone. The warrant possessed nothing. Molina talked about, in the future, with respect to intrusion into the digital media sense, that there should be a minimization protocol, and talked about in the future, perhaps we'll consider one. Later on in Commonwealth versus Snow, the court also referred to, the court established that a warrant authorizing an unfettered search of a cellular telephone without restriction of reasonable temporal limits was improper. So I'd suggest to the court that I challenge that down below. Obviously, I got the ruling on the initial probable cause aspect of the search of the phone, because and he's a very, very experienced, very good, both on the prosecution side and defense side, judge when he was an attorney. He understood exactly that there was no probable cause to search Chris and Chris's phone, that the actual article that they actually grabbed onto and received, when you look at the face sheet of the warrant, nothing indicated that they had the right to search the person. And I'd suggest to the court that that's the way the court ruled. Are there any other questions?
I don't see any, counsel.
Thank you.
Thank you very much. The case is under advisement. Thank you both.
Thank you.
Our next case is Commonwealth versus Patrick O'Shea, docket number 24P501. Good morning.
Good morning, Your Honors. Genevieve Henrique, may it please the Court, for Mr. O'Shea. OUIs are tried in Massachusetts every day in the district courts, and certainly a contention that there was insufficient evidence, especially for impairment of the three elements, is not something new to this court. However, I think it is important to note that in the case that presented before this panel today, neither the Commonwealth nor myself as counsel for the appellant were able to draw too many comparisons to the facts as presented for, the evidence as presented for impairment. And that is because the evidence was so de minimis that cases that would be comparable do not go to the jury. So instead, what we have to look at is a body of case law that had significantly more sufficient evidence than this jury ended up having to consider. That, during a trial fraught with error as to the way impanelment proceeded and also impermissible testimony by the officer, certainly resulted in a violation of Mr. O'Shea's due process rights.
So can I ask you, I agree that we see cases where there is significantly more impairment. But can I give you my list of where I get impairment from the record and ask you to comment? Okay.
Certainly.
So we have that he parked awkwardly, not directly straight in the parking space. That when Osgood was finally able to rouse him into consciousness, he slurred. He said he had been consuming alcohol. He was so unsteady on his feet, he had to use his car for balance. There was an empty liquor bottle in the vehicle. He was disheveled, unsteady, and had slurred speech, and the sergeant could smell odor coming from him, an odor of alcohol coming from him. So do we see cases with stronger impairment? Certainly. But in the light most favorable to the Commonwealth, why is that not sufficient evidence of impairment?
If I may go back first and just disagree with my read of the record, and certainly if my memory does not serve me correctly, then I'm sure Commonwealth will point it out. But I would suggest that he states he was drinking at lunch. I do not believe he states that he was drinking alcohol. So I think that that is important. I understand that
So if I have Diet Coke for lunch and someone says to me, were you drinking today? And I said, yes, I was drinking, the assumption is I had Diet Coke?
I think it is important that he doesn't state alcohol. We have no idea what he was drinking. I do think that's important, and in particularly because he says it was at lunch, and this is this is into the evening. This is into dinner time. So yes, I think the statement that he was drinking at lunch and the fact that he does not say alcohol or any specific details is important to the sufficiency argument. Also, Your Honor, you stated that there was a bottle. My read of the record is that it was a bottle, it was a nip, and it was empty, and there's no indication as to when that was consumed. He's clearly somebody who keeps nips in his car because there are other ones that are full. So what does that tell us? It doesn't tell us anything. It doesn't tell us when that was consumed. And again, it's not a handle. It's not a handle that's 3/4. It's not a handle that there's some drops on the console. So I would state that, and then in addition to that, just again going back to the read of the record, there's, as we know, and certainly we'll get into the permissible statements, the arresting officer states no odor of alcohol. Yes, the sergeant on duty mentions odor, but and he mentions it as a mild odor of alcohol.
Are you looking through the lens of the light most favorable to the Commonwealth?
I am looking in the lens of light most favorable to the Commonwealth, and then from a totality standpoint, looking at the other errors that were committed throughout this case, and particularly, so now if we turn to the Canty errors, clearly the third element that protects against, that has been found to protect against errors where an officer impermissibly testifies to an ultimate conclusion.
And we have two sets, right? We have a preserved and an unpreserved.
Correct,
Okay.
right. So, and I would suggest that it would, right, as far as the impermissible evidence.
The thing about the doctor was preserved, everything else was not.
Agreed,
Okay.
yes. Well, the thing about the impermissible expert testimony was preserved. And it wasn't just a statement to the doctor. I would suggest a statement as to a doctor told me or how a doctor taught me, that was sustained. And as Commonwealth pointed out in their brief, it was sustained based on impermissible hearsay, not that it was impermissible expert. But there was an entire line of questioning there resulting in evidence that I would suggest was objected to and preserved, that was impermissible testimony that was allowed, that was admitted. That it was just the portion as to the doctor telling me that was sustained. Then you have the impermissible evidence as to the ultimate conclusion of law that was a violation of Canty. That, I would suggest, was not preserved.
Here's what I find fascinating about Canty, is we have, and I'll talk to the Commonwealth about this as I always do, we have so many Canty arguments on appeal. I've not found a case where we have reversed on a Canty violation. We have said it was error, but we haven't reversed.
And I think you have said it was error up against backdrops of cases that have overwhelming evidence of impairment, and we don't have that here.
All right, so if we could take them one at a time. I think the first thing that you argue about with Osgood is that, quote, well, slurred speech is, quote, a sign of someone that's been operating under.
Correct.
Okay.
Yeah.
Then, here's where I struggle with this Canty analysis. we know that the jury's been told they are being seated on a case for
Of operation
OUI,
under the
and all the questions that get asked about whether you can be fair and impartial on an OUI case. And so I see your point, but the jury knows why they're there, so help me get to prejudice.
They know why they're there, but now it's 3 times.
Substantial
It's
risk.
3 times that she says. And then I got.
So it's the number of times she said he was
I
arrested for
think
OUI?
that can go to the weight
The
of the.
third time it came out on cross-examination.
Yes, it did. So it's not, right, it's not-
Why should that be held against the Commonwealth?
It came out in cross-examination. I think it can still be considered as part of the totality of whether or not the defendant received a fair and impartial trial. You're right. I did not argue it as an effective assistance, but you have at least twice, and then I guess you could say it was emboldened by the cross-examination. But yes, Your Honor, I understand where you're going there. But you have 2 times in the case in chief where she does ultimately testify to a conclusion of law, and the Commonwealth concedes that's a violation of Canty. So I don't think, yes, does Canty maybe need to be clarified on the issue, but I think as far as this court has found violations, just as you just stated, Justice Flake, that this court has found violations, but then found them not to be reversible error. I don't think now we turn to these statements and say, oh, well, they're not. They still are. They are consistent with the statements that have been found to be violations. Your question back to whether or not it then amounts to reversible error, and I would suggest, or whether it created a risk of substantial likelihood of miscarriage of justice, I would say that this is the case that it did. Because
Well, we're substantial risk here, right? Not
we're substantial risk here. That's why I did just try to correct
And you
myself.
say that because of all of the other things, what your argument is with respect to sufficiency as well as jury impanelment, right?
Yes.
You're saying it's the collective
I am to
sort of tapestry of this case.
Right. And because we don't decide these cases in vacuums, and we need to look at everything that occurred from beginning, from impanelment to the verdict. And turning to the impanelment, it was problematic. And it was particularly problematic because of and going again to that idea that we don't decide these cases in vacuums. Juror 76
I was following you straight down that path until we got to the point where there was a remaining peremptory challenge. And that twice defense counsel said, satisfied with the jury.
And certainly have struggled with this, but we don't know who else was,
Problem, we don't know who was next. We don't have a record that we can look at.
we don't know who is next, we don't know, right, so we can't really, and I think
Whose fault is that? Defense counsel, the judge, the prosecutor, everybody?
as to not creating a record or to not
Create a
using the
record.
preemptory. Moving forward, I mean, I think that
If the next 5 people had, family members, God forbid, killed by a drunk driver, I would understand.
Right.
But we just don't know.
And so we don't, but let's even say it was strategic.
But we don't
Is
know
it-
because there's no motion for new trial.
No, there's not. But really to really focus on the abuse of discretion standard. And again, not looking at the vacuum, looking at the fact that jury 76 remains. And then juror 77 and 86 remain, and the fact that there was not a meaningful and fair inquiry. And I know I'm not going to recite the language of Rios to you, Your Honor, I understand, but it was not there, and it was certainly sought. The counsel sought it, particularly for juror 77, sought a more meaningful inquiry, and it was not given. And ultimately, I would suggest that even specifically looking at juror 77, I believe it was a female, stated that her impartiality, when she finally answered whether or not she could be impartial, it was in the context of whether her experience with Anon she could remain impartial. It never circled back to an inquiry of whether or not she could decide this case fairly with a child that she takes care of who is a victim of an OUI accident. 76 gets removed for cause because he thinks that there was some unfair prosecution, and she remains not for cause, even when it was objected to. And I would maintain that there was an objection to her remaining for cause, and there was a request for cause, and that the denial was objected to. That is problematic. And again, in a backdrop of a case where we have Canty violations, where we have impermissible expert testimony that was objected to, where we have very de minimis evidence as to impairment, the way the impanelment played out is problematic and violated my client's due process rights.
Can you briefly touch on the deterioration argument about the video?
Briefly, yes, I can. I think, again, I'm going to go with the back, that it was an argument where a motion for a directed verdict was denied. There is very insufficient evidence. I think any strategic error is, or non-strategic error, but any error is important to look at in this case. And it was not strategic. He states straight out, oh, we'll kill two birds with one stone. He throws it in there. Certainly, it's not the turning point of the case by any means. I'm not going to even try to suggest that. If there are no further questions, I'll rest on my brief.
I don't see any. Thank you very much.
Thank you, Your Honors.
Good morning. May it
Good
please the
morning.
court. Dylan Punch, 303 certified practitioner on behalf of Middlesex County for the Commonwealth. Joining me at council table is Assistant District Attorney Emily Walsh.
Well, welcome to the appeals court.
Thank you. And the Commonwealth would ask that this court affirm the defendant's convictions of OUI third and operating after suspension for OUI while OUI, because the conviction was supported by ample evidence and all the other errors, claimed errors, were either not errors at all or did not prejudice the defendant. And the Commonwealth's position
Can we
is that—
start with sufficiency, because you make many arguments, including on, I believe, the issues with the police officer's testimony, which we'll get to in a minute, that this was overwhelming evidence of impairment. I don't think it's overwhelming. Whether it's sufficient is a different question. So could you give me the list of evidence that you say suggests that the impairment was overwhelming?
Yes, Your Honor, gladly. So the defendant was unconscious in his car for approximately an hour, parked awkwardly in front of a liquor store. Bystanders were trying to rouse him into consciousness, were unable to. They actually had to call 911. The officer arrived, called out to him. He didn't wake. Tapped him on the shoulder. He didn't wake. He had drool spewing down his mouth onto his chest. She actually had to administer what's called a sternum rub, which is to elicit a response to pain. The defendant, he woke up, he was dazed and confused. He was giving incomplete answers about his basic, where he lived, his address.
And so far I'm with you, but that could be for any number of reasons, including a medical incident. So how do we connect that to the alcohol?
So then he admitted to drinking. He was unsteady on his feet, holding on to the car door. There was several full nip bottles in the car, and then there was one empty one. He was delayed in his responses during booking. The booking officer said that he could smell booze coming from him, and he was disheveled.
Do we know what he was drinking? I know at 108 and 109 of transcript 1, he said he was drinking at lunch. Do we know what he was drinking?
We don't, Your Honor.
And what's the reasonable inference from that statement? That he was drinking alcohol, Diet Coke, coffee?
Your Honor, drinking alcohol is the only, to the Commonwealth's position, that's the only reasonable inference, especially coupled with the other signs of intoxication that were present.
I think generally, counsel, when we see overwhelming evidence, generally, it's when someone's driving all over the road in such an, even though every juror is instructed that it's not required, that the defendant actually drove in an unsafe or erratic manner. I mean, here we have, no evidence of driving. So the evidence that's overwhelming is just of his physical appearance, right, inside of the car, the evidence of his statements, the nips, and the way he parked his car, right?
I don't necessarily agree, Your Honor. I would posit that the reason that we don't have this overwhelming evidence of how he's operating a car is because he was intoxicated to the state that he was unable to remain conscious, so operating poorly was not.
Not suggesting that may not be right. It's just that generally, when there's such an overwhelming case, it involves operation. Here, there's none, so you're stuck within what he looked like, what they saw, and the way that he parked his car and held on to the side, right?
Essentially, yes, Your Honor. Now, moving on to the juror issues.
Before you do, did he actually, was the testimony that he said he was drinking at lunch, or was it just earlier?
I recall I was drinking at work.
At work, right, but not necessarily at lunch, right?
Correct, Your Honor. That's how I recall it. Now, moving on to the juror issues, these two challenged jurors, jurors 77 and 86, they both unequivocally stated on the record that they could remain fair and impartial. And neither were challenged for cause, nor were there any peremptory challenges exercised. And then, as this court noted, that the defendant twice indicated that he was content with everybody on the jury. And that, coupled with retaining the peremptory challenge, kind of defeats the argument that he was unhappy with his jury. It seems as if he was content with the jury until it convicted him. And
So is the reason juror 76 was dismissed is because there was a motion to excuse him for cause? Is that the difference?
I believe that was on the prosecution's behalf, Your Honor. If I remember the quote correctly, it was that he felt he had previously been railroaded by the
Yeah,
Commonwealth.
Yeah, but ultimately, he also said he could be fair and impartial, but he was excused for cause. So is the difference between that juror and the other two just that there was an actual request to excuse him for cause?
No, I would say that just by what he stated, Your Honor, railroaded is much stronger language than what either 77 or 86 used. For instance, 77 indicated during the group voir dire that there may be a reason she can't remain fair and impartial. Then during individual voir dire, the judge spoke to her. She stated she could remain fair and impartial, and ultimately it becomes a credibility determination for the trial judge, Your Honor. And the trial judge found 77 and 86 both fair and impartial. Now, going on to the argument of ineffective assistance of counsel due to the failure to exhaust these peremptory challenges, but because these jurors were fair and impartial, that couldn't, even if that had been error, it could not have prejudiced the defendant. But the record shows that the defendant himself was actively involved in deciding whether and when to use peremptory challenges. The only one that was exercised was at his specific behest, not his attorney's. And of course, he said he was content. Now, to the deterioration issue, of course, the case doesn't necessarily live and die on this one, but this footage could not have deteriorated the Commonwealth's case, so it would not have mattered regardless when it was introduced. It showed the defendant standing and walking, essentially, which is not mutually exclusive with impairment. And as to the challenge ultimate issue testimony, that was improper under Canty. Of course, there was no objection, so there's a higher standard review of the substantial risk of a miscarriage of justice. And
So I'm not intending to shoot the messenger, but every time I have a Canty issue, I have this conversation with the prosecutor so that I ask that it get relayed to your office. And I'm sure Attorney Walsh will do that for us. There's got to be better training for the line prosecutors and the police officers, because there are ways to ask this question to not create an appellate argument. And although Canty says it's error, as I said to sister counsel, I've not seen a case that we've reversed on a Canty error, but Canty's been around for a while now, and these same mistakes continue to happen. And I truly believe it's a training issue for both the prosecutor and for the police officers. And yes, the jury knew that OUI was the charge, but every time that officer testified, she sort of doubled down on that. And at some point, enough is enough. I don't know that that's the case here, but why go down that path? So that's my preach for the morning, and I will move on to a question for you, which is, do you agree with opposing counsel as to which of these arguments we're looking at substantial risk? She claims that there is at least one that was preserved. And do you agree with that?
yes, the testimony about the doctor,
Okay.
Your Honor.
And are we looking at, I found it interesting because are we looking at under a Canty analysis, or are we looking at as improper expert testimony, or kind of both?
So it seemed to me as the primary issue was improper hearsay testimony, Your Honor. And
That's how the judge ruled on it, but that's not how defense counsel on appeal has framed it, right?
that's correct, Your Honor. And I believe that the hearsay.
Does it matter what the judge's ruling was for how we're looking at it? It is preserved.
It is preserved, Your Honor. I wouldn't, even though it's framed as expert testimony, it's a doctor once told me you can't smell booze. I don't, considering that there was evidence before the jury that the booking sergeant could smell alcohol, a unknown doctor saying that, the officer essentially trying to justify why she may not have been able to smell it.
The officer used the word booze?
I don't know if she used the word booze. She may have been saying alcohol, Your Honor. But I believe that this, especially since it was sustained and the jury was, of course, instructed not to consider any sustained objections, I don't believe that it affects the outcome here, Your Honor.
And then on the Canty issue, you argue mitigation. You list the 3 Canty factors. Of course, we agree the officer was a lay witness. The instructions mitigated any error. But you also say that the Commonwealth presented overwhelming evidence of impairment. Assuming I disagree with you that it's overwhelming, but it's sufficient for the sake of this question, does that meet the 3 Canty factors for mitigation?
I would say yes, Your Honor. It's certainly strong evidence here, and especially considering the error was preserved in Canty, whereas here it's not. The Commonwealth's position is, there is some disagreement, but the Commonwealth's position is that it was overwhelming, sans the operation, but due to the strength of the evidence, the result would be the same. If there's no further questions.
I actually have a question. So you're a 303 student,
Yes, Your Honor.
and credit to you for coming up here and doing a job against, I think, a very good counsel who made a convincing argument as well.
So everyone in the courtroom understands this is a student attorney.
Okay.
No need to be nervous now.
Now I forgot my question a moment ago. I didn't. So, I'm not sure if you're interested, and you don't have to answer this, in appellate work or trial work. But in your 303 experience, have you also done trial work?
I have not, Your Honor. I interned at the Middlesex Appeals Bureau, and I was actually recently hired, so that's the path I want to pursue.
Congratulations.
Well, that's wonderful to hear. And just to kind of double down on what the chief has said, you can't control necessarily what your witnesses say. Right? This is in the district court, and having been there for many years, it's surprising what people say.
I could see that, Your Honor.
Okay. And that's part of the challenge and the advocacy for both sides. But there's also a responsibility that a prosecutor has to prepare witnesses. Even witnesses that don't testify often, who sometimes have done this for a long period of time and revert back to the old way that it was done. But just take that with you, that when you do practice and you prepare witnesses for telling their version of what happened, that they comport with something that wasn't written yesterday.
I will, Your Honor. Well, I'll have this in mind.
But congratulations, and
Thank you.
thank you.
We will take the matter under advisement. Thank you all. We are going to take a brief morning recess. When we return, we will hear the Springfield Water and Sewer case. If the lawyers are here on the DCF matter, could you just check in with my Assistant Chief Court Officer so you understand how that case is going to proceed? Brief recess. these people. Only with you. All right. Our next case is Springfield Water and Sewer Commission and others versus the Massachusetts Department of Environmental Protection. I just want to check in with counsel before we start the record. My understanding is that the Attorney General's office and Charles River Watershed will be splitting their time 12 and 3, and that the plaintiff, appellant, one lawyer arguing the whole thing. Is that correct?
That's correct, Your Honor.
All right, Mr. Durning, when you're ready.
Thank you, Madam Chief Justice. May it please the Court, I'm Attorney Peter Durning from Verrill Dana on behalf of the appellants, 18 public water suppliers who hold registrations under the Water Management Act, and an industry association that advocates for water resources stewardship. I'd like to address 3 issues in my comments and respond to any of your questions. First, importantly, the standard of review to guide the Court in its de novo review in this action under General Laws, Chapter 30A, Section 7, is a 2-step process set forth in New England Power Generators 480 Mass 398. This is not a 30A14 matter where there's been an administrative decision with fact-finding. It is a facial challenge to determine if a regulation is consistent with the agency's authority under the relevant statute. The first step in the analysis is to determine if the legislature has spoken with certainty on the topic using conventional tools of statutory interpretation, and if the statute is unambiguous, then the court must give effect to the legislature's intent. Only if the statute is ambiguous does the reviewing court proceed to the second step of reviewing whether the agency's approach may be reconciled with the governing legislation, and at that time giving substantial deference to the agency's expertise.
Do you agree or disagree that the DEP has the authority under the Act to enact amended regulations?
To enact regulations or to enact these amended regulations?
Generally speaking.
Generally speaking, I do.
Okay. And here, do I understand you to say that the amended regulations deny or infringe your rights?
That is our position.
So there's a lot of time spent in the briefs about this word infringement.
Yes.
Help me understand, if you as a registrant are still able to withdraw water, but there are some restrictions during some periods of time when the DEP says there's a drought, how that is an infringement on your rights?
Certainly, first setting aside that the way the amended regulation is written, I don't think it's limited in time, but even so, what we get from the statute and from the Fairhaven case is that the DEP does, and in my first response to you, does have the authority to adopt regulations that can be imposed on registrants. But what the SJC said in Fairhaven is that those registrations cannot infringe on the registrant's existing withdrawal. And in the event that the regulation, as is the case here, prohibits the registrant from withdrawing water at a certain amount of time, that is infringing on their ability to use water.
How does it prohibit withdrawal? I'm not understanding.
So in this case, Your Honor, the amended regulation is targeted to prohibit end users from making certain withdrawals. And yet, as we maintain in our papers, that is a little bit of sleight of hand. And what they're really trying to do is prevent the water from being withdrawn. And indeed, during the matter before the Superior Court, the Assistant Attorney General stated that the goal of the amended regulations is to, quote, keep the water in the ground. And that's in the hearing transcript at the record appendix at 1231.
That might be the goal, but the regulation on its face does not prohibit the withdrawal of water.
And that is what it is doing, Your Honor. If the demand, if they are curbing the demand that triggers that withdrawal and trying to, in their own words, keep the water in the ground, then in effect they are blocking or prohibiting or restraining or infringing upon the registrant's ability to withdraw water.
And in Fairhaven, the SJC noted that if the conditions become so onerous that in effect it's infringing on withdrawal rights, the remedy for that is to go through the adjudicatory process, which the agency has now established in its new regulations. It's set up an adjudicatory process. So why is that not the remedy?
That is mentioned, Your Honor, but the manner in which the amended regulations were promulgated were, we felt, an infringement. It demonstrated an infringement on its face, that this challenge through 30A17 was open to us, and we made that pursuit.
How do you get past the statement in Fairhaven? So the conditions in Fairhaven, I think they're more onerous than the regulations here.
I would disagree, Your Honor.
All right, well, there's still a demand restrictions, right? Conditions mandate adherence to the seasonal demand management, restricting outdoor water use. And the court said that in imposing these conditions, the department is seeking to restrict the manner in which water is used, but it does not seek to decrease the total water usage below the existing withdrawals to which the registrants are entitled. So how do we distinguish that?
So I think what's important to understand about Fairhaven is that it really is a decision about the process in which the DEP pursued.
Understood, but they made this commentary about the conditions that they are not a restriction on the withdrawal rights. It's a restriction on the manner in which the water is used.
There is that statement, but I think that, again, Fairhaven wasn't making a substantive decision about what constitutes infringement. I think that's what this case is going to determine. And to the extent that those regulations or the registration conditions that were discussed in Fairhaven, they were seasonal. These ones are not. This is whenever the department or the secretary establishes a drought, it can continue. And indeed, the record demonstrates that the department anticipates that these droughts could span years, and a drought could be declared in August and continue through the winter, as happened recently. So there's no set period of time when the regulations, under these amended regulations, are going to be imposed.
There's also a condition in Fairhaven that each registrant's water consumption is to be limited to 65 residential gallons per capita per day. That's not time restricted.
No, I would agree with you there. It's not time restricted. But again, I don't believe that the Fairhaven case confirms that those provisions are permissible, because they were so concerned with the process that they did not rule on those conditions. But what they did give us was the directive that there could be no infringement on the existing withdrawals, and that recognizing that the withdrawal right is grandfathered.
Would a time restriction cause you to say it was no longer arbitrary and capricious? In other words, was there anything the DEP could do vis-a-vis your withdrawal rights and balancing the need to conserve? Or do you say there's no regulation that would be acceptable?
Pardon me, Your Honor. I believe that there are things that they could have implemented through regulations. They could have made it enforceable that the systems undertake investigations and audits to make sure that there are no leakages in their lines. They could have imposed measures upon them to improve the delivery so there's no waste. But in the manner in which these regulations are promulgated, they are targeted towards preventing the system from undertaking withdrawal, and we think that is an infringement.
And no withdrawal. There's not a set of circumstances where a limitation on withdrawal would meet your standard.
I would have to see it, Your Honor. The manner in which these amended regulations are written, it is indeed an infringement. I would have to see what else besides time limited it would be, but
it's only when there's been a declared drought emergency, correct? With different kind of three different categories of the type of drought that it would be considered that would affect your ability to withdraw water, correct?
That's correct, Justice Walsh, but I believe, again,
So I'm just trying to, when you said, I'm trying to think of an instance, so the whole Commonwealth is on fire. Every little bit of it, okay? It's top tier. And we have that, your argument is we can still draw our water and wash our cars. That's what the result would be. They cannot regulate under that type of situation when it's an absolute emergency, but because you got this ability to be protected under a particular provision of the rules, if I were to accept your argument, then I'd have to say, well, then go wash your cars. You're 100% allowed to wash your cars in this situation, right?
right, I think my reaction to that would be, yes, we have a piece of paper, but we have it because the legislature made a legislative bargain effectively, and it decided that for those users with existing rights, it was going to deliberately grandfather them under the Act.
So I'm just trying to understand your argument. There's nothing they can do to ever interfere with your ability to draw water, even when the whole Commonwealth is burning down.
As we established in our papers, the legislature contemplated giving that power to the Secretary in the Water Management Act, and they deliberately decided not to include it. What they included was Section 15, which gave the rights in the event of a water emergency. Fairhaven says in the event of a water emergency, as declared under Section 15,
right,
that right can be infringed. Section 15 does not give that power to the Secretary. So although it may create an awkward circumstance, Your Honor, that's what the legislature prescribed.
I mean, Section 15 does permit a restriction on withdrawal rights.
It does.
And the regulation here does not, because it's not a restriction on withdrawal.
Well,
So your opponents argue that, the Commonwealth is on fire, that there's nothing the DEP, no restriction the DEP can impose on end users to conserve water. Isn't that right? There are no restrictions that you would say would be permissible in that situation.
within an area that is served by a registration,
So
that would be inappropriate.
53% of water users can water their lawn to their heart's desire in the middle of a fire. Commonwealth is on fire in the middle of a drought. 53% can, and the other 47% are just kind of on their own.
Right. In the extreme
Isn't that right,
example,
though, that is there any restriction on end users that you think would be permissible?
in this circumstance, I don't. That's not to say that the folks that I represent are professional water managers, and if the Commonwealth was on fire, it's not that they wouldn't collaborate or cooperate.
Isn't that the precise, and I'm using the language of our cases, the absurd result that we are supposed to not reach when we're looking at the text of legislation?
But what we have in this circumstance is not only an unambiguous statute, but it's been twice reviewed in the court in Fairhaven and in Concord, and they came to the same conclusion. I mean, in footnote 4, the SJC says that the registrations are forever. How often does the Supreme Judicial Court make such a broad pronouncement? Yes, this is an extraordinary amount of authority that was given to the registrants, but again, that was the general court's decision that the legislative bargain that they struck was that there would be created these two different categories of usage. And if you look at Section 7 of the Act, the manner in which the legislature takes power to influence and restrict those users is very vast. They deliberately did not include that in Section 5. Yes, they gave extraordinary powers to these registrants, these existing users, that use was otherwise, prior to the Water Management Act, equally as unfettered and unable to be restricted in the scenario that you're giving. That was a continuation, an acknowledgement that those rights existed. And that's what the legislature opted to do. That's the power of the Water Management Act. That's why we're here, is to uphold that grant that they were given. Anything further?
I don't see any other questions.
Okay, thank you very
much. Attorney Dundon, are you going to argue first?
I am, Your Honor. Thank you. May it please the Court, Louis Dundon, Assistant Attorney General for the Commonwealth, for the Department.
Before we get into the substance, can we talk about the standard of review? Because you seem to disagree.
We do disagree, Your Honor.
Tell me what the standard of review is.
I think the Court should use the standard of review the SJC used in Fairhaven, which is there is some ambiguity of the statute, and the agency gets deference in the case of ambiguity. I confess that I struggle with the appellant's argument here about how there could not be ambiguity when the point of their argument is to write a new rule into the statute that's not written in the statute, the right to maximize their demand of the use of water.
Do you think the result is the same whether we use the standard of review you've articulated or that of the plaintiffs?
Well, I guess, Your Honor, if this is unambiguous, the language favors the Commonwealth. I think the statute says exactly what the registrants get, which is the right to, quote, continue existing withdrawals in Section 5. And as the appellants explained in detail, the legislature took a lot of care and time to figure out what they were going to give the people who were first in line, and what they gave them was, by definition in Section 2, the right to, quote, remove or take water from a water source. So that's what they got, the right to take water from the ground, not any restraint on the use of the water thereafter. So if that's unambiguous in the Court's mind, then I think that favors the Commonwealth. I think what the appellants are actually making is a structural argument, so I don't think that the rule applies in the way the appellants are applying it properly, and I think that's what the SJC saw in Fairhaven. One other statutory point that didn't come through as much in the briefing is there's another thing in the statute that makes clear that what the legislature cared about, in addition, was to what extent the registrants were going to conserve their own water and how they were planning on doing that in the future, not how they were going to maximize their water use and sell a commodity. And that's in Section 6. When they apply for their registrations, they have to explain to the department what's their current situation on water conservation measures and what are they planning to do going forward. And presumably, the legislature expected the department to take account of that in determining how to allocate water. So when you take all the pieces of the statute together, it's clear that this is a statute about water management and water allocation, and the legislature cared about making sure residents of the Commonwealth had water, and so what they gave to the registrants wasn't the right to sell as much of a commodity as possible, it was the access to a certain amount of water, the assurance that that water is going to be available and the state wouldn't get in the way if they needed it for their people to drink.
And so in the time of a drought, do the registrants still have priority over the new users?
In the time of a drought, the registrants still have access to withdraw their full amount of water by the terms of the statute. The users are restricted in what uses they can use on them during that time, but they do get to withdraw the water if they want to.
And is it true that a drought can be declared for a substantial period of time?
That's true. It depends on what you mean by substantial period of time, but it is true that it has been declared for many months in the past.
And how, as a practical matter, let's assume it's a 6-month drought, how does that as a practical matter impact the registrants on a day-to-day?
So on a day-to-day basis, some portion of their users would be restricted in some of the uses of their water, depending on how serious a drought is. That might be they can only water their lawns on Thursdays, or it might be you can't do any of the non-essential things that are listed in this, that are set up in the statute.
But the proverbial spigot does not get turned off.
Correct. They can still go to their water source and take the water from the ground, and they can do whatever else they want with it that the law allows.
So your opponent argues in his brief that the conditions for registrants are actually more stringent than the conditions on permittees because there are seasonal limits on the permits. How do you respond to that?
First of all, I'm not sure it would matter for the sake of this case if that were the case, but I think that the conditions being put on the users here could be for a particular period of time. It could, in a particular instance, last longer than they might on a permittee. Like the permittee is a seasonal restriction, and a registrant theoretically could have a drought that lasted longer than that period of time. But I don't think that violates any rules of the statute.
Why isn't that arbitrary and capricious?
Because nothing in the statute says that it can't be the case,
Well,
Your Honor.
why are they treated differently?
Well, they were treated differently by the statute. They were given different rules and rights under the statute by the legislature. The legislature said the department had free rein to impose relevant conditions on the permittees.
The department's setting up regulations that are treating registrants different than permittees. How is that rational?
Because they're following the legislature's lead saying that is the case, like specifically creating two classes and treating them differently. The legislature created two classes of water withdrawal with water providers. Ones that were there at the start that could get registrations and ones that came along later and needed more and got permittees, and there are two separate sets of rules that apply.
I understand there are two classes, but any differential treatment still has to be rational. So is there an explanation for why there are seasonal limits on permits, but not on registrations?
I think that the idea of what kinds of restrictions make the most sense has evolved over time, as one would expect. And I think that as the permits get renewed, these last for periods of years and things, the registrants last for 10 years. As they get renewed, the expectation is they will flip over to have something closer to what the registrants have now, just waiting for the
How
time.
often do permits have to be renewed?
I don't have the specific answer off the top of my head, Your Honor. I'm sorry.
Okay, that's all right.
It's certainly in the section on permits, but I don't have it right in front of me, Your Honor. So, to the point, the right that the registrants got was this right to withdraw, and that's very different than what they're asking for here. What they're asking for here, to be sure, they want that right, the right to withdraw water, but they also want a second right to maximize their sale or demand of the water. And because that doesn't appear anywhere in the statute and it's inconsistent with Fairhaven, they need to suppose a reason for the court to create it here. And they do that by relying upon this principle that they only withdraw the water that their current users demand in the moment. And what that means is, it means that any time a drop of water is conserved, by their logic, a drop of water isn't withdrawn, and it's therefore infringement. But the problem with that rationale is, if the appellants are only choosing to withdraw the exact amount of water that their current users are using, that's their choice, not the Commonwealth's. There's nothing in the department's regulations that prevent them from withdrawing more water.
Well, can I ask you, at page 21 of your brief, you say, I hope this is your brief.
Me too.
Registrants' withdrawal entitlements are annual volume limits expressed in average gallons per day for specified days of operation per year. The registration renewals do not limit the actual volume of water withdrawn on any given day, week, or month. So I just want to make, and that's different than what Fairhaven said. So what I want to make sure I understand is the registrants are not limited in how much they can take, they're limited in what they can do with it.
That is what the drought restrictions do, yes, Your Honor. Yes.
And so if they take it, but they can't use it, it just sits until they can use it.
Well, they can use it. That's part of the problem with their analysis, and it was actually where I was going next, Your Honor. To get to where they need to go here to imply this rule, they act as if there's nothing else they can do with their water. But there of course is, and they talk about some of those things in their brief. They could sell the water to other jurisdictions. That shows up in footnote 6 on page 45 of their brief. They could store the water. That comes through in their arguments about the age of the water and complaints about having it sit in their system for a while. There could be new users that come online in a given year, and that demand could be used for it. So there are other things they could do with their water. They simply choose to only withdraw the exact amount, they say. And so that creates this sort of need for this new rule that they're asking the court to create that doesn't have any basis in the statute and is inconsistent with its purpose. But I think, importantly, it's not just that this new rule isn't consistent with the Act and doesn't appear in the Act. It's that this new rule, as Your Honor was getting to earlier, would bar the department from creating any reasonable conservation restrictions on any registrants, 53% of the water, as Justice Shin said earlier, which is contrary to the explicit holding of Fairhaven, which specifically said the Commonwealth had this right to put conservation measures on registrants. If any demand restriction is an infringement, then any conservation restriction is illegal. Now, the appellants say that they're not actually doing that. They've said today that there are ways the Commonwealth can use the water, but they never bother to explain exactly how that works, what the Commonwealth is allowed to do, what the principle is, what they're setting to in the statute to support that. This becomes clear when they try to come up with some examples of what would pass muster under their standard, which happens at page 11 of their reply brief. They give 4 examples, but they provide no logical explanation as to why those examples are permissible and why what the Commonwealth is doing is impermissible. For example, you heard some of the examples today. One of the examples they give is to, quote, detect and repair system leaks, and to, quote, upgrade infrastructure. But why is that permissible under their rule that any reduction in demand is an infringement? If your sink is leaking, that water coming out onto your sink, you pay for that. That's not free. That's demand to the system. And so if you go around and fix all the leaks in the system, make them upgrade their water mains to reduce the leaks, that's a reduction in demand. Why is that reduction in demand okay, but limiting flower watering to Tuesday is not okay? There's no explanation as to why one is okay and not the other. Similarly, they say that it would be okay for the Commonwealth to, quote, provide customer outreach and education on, for example, water-efficient appliances or drought-tolerant plantings or rain barrels. Why is it okay to convince users to reduce their demand, but not say you can only wash your car on Thursdays? There's no explanation as to why one is okay and not the other, and that's because there is no intelligible principle in the rule. Their rule bans all conservation restrictions because all reductions in demand become an infringement.
Before we lose you, because the light is now yellow,
Yes.
There was an amicus brief filed in this case, and it's a significant record, so I just want to make sure. Judge Hom did not rely on climate change principles in deciding this case, did she, in your view?
I read the decision this morning. I don't believe she mentioned climate change in it, but I would have to read it again to be 100% sure.
That was my memory. But
Could I ask you one last question? So the intervener says that with respect to the variance pathway, that the evidence supported that 3 years of storage capacity would be adequate, but not 2, and the department ultimately settled on 2, and your opponent says that that is not evidence-based. Do you have a response to that?
I do, Your Honor. I mean, it's in our brief. I direct the court to pages 36 and 37 of our brief, as well as footnote 12. The department laid out in its brief some of the things it relied upon to make its science-based determination, and that included things like the Secretary's drought management plan, which documented drought history for years, the department's own observations during the last droughts over the last decade. That was what it used to make an assessment of how much risk it could tolerate for a drought problem with how much flexibility it could give.
That's really what it is, right? A risk assessment based on the duration of prior droughts?
Exactly, Your Honor, exactly.
All right, now we'll hear from Mr. Racer.
Thank you, Your Honors.
Thank you.
May it please the Court, Harley Racer, Rich May PC for the interveners, Charles River Watershed Association. Fairhaven looked closely at the Act and held that the water management, including water conservation, is an important purpose of the Act, and that the Department has broad authority to issue regulations to carry out this purpose. Fairhaven made clear that the Department's broad authority includes conservation conditions on registrants when imposed by regulation. The conservation regulations here are well within the Department's authority. Fairhaven mentioned that the Department's broad authority to meet the purpose of the Act at least 3 times. It's critical for this broad authority to be affirmed under the Fairhaven standard as the Commonwealth faces an uncertain and changing climate in the coming decades, which will impact the health and viability of our watersheds, water supply, rivers, and tributaries, some of which have run dry in recent extreme droughts. The broad authority here is necessary to meet the purpose of protection of natural habitats and future water supply, short of an emergency that imminently endangers the health, safety, and welfare of the public. These conservation measures are critical to be able to respond in real time to mitigate the effects of drought conditions before endangering the health, safety, and welfare of the public. As noted by the Amici, several droughts have occurred in recent years, resulting in economic losses, shortages in public water supplies, and low stream flows that degrade fish and other wildlife habitats. These conservation measures are of limited duration, specifically in response to and tied to drought conditions, applicable to limited non-essential uses, with many exceptions, and do not run afoul of the Act or Fairhaven because they do not infringe on the registrant's annual withdrawal entitlement for at least 2 reasons. First, there is no affirmative restriction or change to the registrant's entitlement or ability to withdraw water at all. The registrants can withdraw water for all non-essential uses. The registrants can also withdraw water for storage or to sell. The conditions are not in effect during times when there are no drought declarations. The conditions are as to end user, not to the registrant. Second, there are innumerable factors that may cause an increase or decrease in demand. The record shows that registrants have reduced their withdrawal rates over time and that some registrants, including some appellants, have for multiple years not come close to withdrawing their full annual entitlement amount of water. It's baseless for the appellants to claim now that these conservation measures on their face have categorically denied or will categorically deny them their annual entitlement to withdraw water. Regardless, as contemplated by Fairhaven at Note 12, as Justice Shin noted, the registrants, if they believe that the measures in actual practice have denied them their full annual entitlement, they can make that case with actual evidence through the adjudicatory process. But they've not presented any evidence to support that claim here. The public and the natural habitat rely on the department to use its broad authority to adopt these and other conservation measures on all water suppliers and users. And we urge this court to affirm the judgment if you have no questions. Thank you.
Thank you very much. Counsel, I want to thank the three of you. These were excellent briefs, excellent arguments. It's a difficult case. It is under advisement. Thank you all. Well, if I had known we were going to clear out the courtroom, I would have called it earlier. The next case can set up. It's MF versus JW 24P86. But before we go on the record, I want to talk to counsel. On the appellant side, I don't understand why you're splitting time. I don't know if you intend to talk about separate issues, but I can tell you that the panel is not going to be limited to what issues you choose. So do you want to explain to me why you're splitting time?
Sure, Your Honor. So, Evan Piercy for the appellants. We have really two separate briefs here. One is a motion to strike, which was filed by the appellees, and then the other is the affirmative substantive.
Well, the motion to strike we deal with in the ordinary course. I don't expect we're going to have argument on the motion to strike.
If Your Honors do not need argument on the motion to strike, then we don't need to split time. That was simply the intent to
Okay, let me just
parse the
confer with
issues.
the panel very briefly. Do you need argument on the motion to strike? Do you think that's the only thing she's here to argue? Okay. Typically, we don't have argument on motions to strike. The panel, when it's referred to the panel, we take it in as part of our deliberations. With that said, if your associate was prepared to argue that, is that what you're telling me?
Yes, Your Honor, we do have argument prepared on that.
Okay, so
we were also
let me say this.
prepared-
I always want to give people the opportunity to argue before the appeals court because it's such a wonderful experience. But I will say that I don't anticipate, unless you feel very strongly, Attorney Thomason, that you need to address it in your 15 minutes, but it's unusual. I'm prepared to do it, but Attorney Thomason, you do what you need to do when it's your time. Okay, so why don't we then now go on the record if we could, and we'll start with the substantive argument. Mr. Piercy, if you could reintroduce yourself for the record.
Yes. Good morning, and may it please the court. My name is Evan Piercy, and I, along with my co-counsel, Sav Arguello, represent the appellant. Your Honors, the underlying decision to deny MF's request for an extension of the protective order is the byproduct of several errors of law and abuses of discretion. Today, we submit to you that there are two such errors that compel this court to reverse the trial court's decision and remand for a new hearing before a new justice. The first is evidentiary. The trial court excluded two critical pieces of evidence that corroborated MF's reasonable fear of harm. The second I will broadly refer to as the due process issue. I want to first talk about the evidentiary issue. As Your Honors know from the briefs, there are two critical pieces of evidence that were excluded at the trial level. and they both were generated by the Department of Children and Families. One is called a 51B report, the other is a family action plan. Now, both of these pieces of evidence contain corroborative statements that corroborate MF's testimony that she gave during the hearing, that JW wanted her dead, wanted her to die, wanted to kill her.
So under our case law, Frazzado talks about how flexible judges are supposed to be in taking in evidence. And, you know, when I first read the brief, I thought, yeah, this material should have come in. But then I looked at the timeline, and it seems that the other side didn't know about these records till perhaps the day before. And of course, we know that in 51Bs and in many DCF records, there are so much in there that is totem pole hearsay and that might be subject to redaction. So when the judge sitting in the district court is trying to balance what am I supposed to do under Frazzado, the timeliness or frankly the lateness of the submission causes me pause. So what do you say about that?
Sure, Your Honor. And I'm glad you referenced the discretion that the district court has when faced with something like a 51B report that does contain a lot of hearsay, that does contain a lot of double hearsay. We don't dispute that the district court has discretion to determine what evidence is admitted and what is not. And we don't dispute that the evidentiary framework for 209A hearings is a little bit more flexible. But what happened here wasn't a trial judge that exercised that discretion and looked through the 51B report and said, you know what, it looks like there's a little bit of evidence in here that might be a little prejudicial. I'm not going to consider that. Looks like there might be some hearsay that is unfair to JW. I'm not going to consider that. That's not what happened here. What happened here...
Can I interrupt?
Yes, Your Honor.
Does the judge have to make that analysis? In other words, separate and apart from what's in this 51B and what's in this family action plan, if the day before the hearing, despite holding on to it or knowing of it for a significant period of time, you come into court with a big packet of information and say, we'd like to introduce this judge as Plaintiff's Exhibit 1, and there is an objection based out of fundamental fairness of, I'm not prepared. Had you told me about this a month ago when you had it, so despite what's in the report, can't the judge decide at this late time in the proceeding, regardless of what's in there, it's unfair to surprise and to cause this prejudice to the other side? Doesn't the judge have that discretion?
Yes, Your Honor. The judge certainly has that discretion. I would, though, note that that wasn't the objection that was made at the trial level. That was not the objection made by JW's counsel. The objections that were made were, in fact, that these are old. These records are old. They are not, in fact, that old, and that was something, in fact, that JW conceded during the hearing, that they weren't actually that old, and that someone from DCF is not here. Now, putting aside for a second whether someone from DCF needs to be there, which we would submit under this court's case law is not required for this type of evidence, the objections that it is unfair surprise was not something that JW articulated at the hearing. That was not the basis of the objection.
It might not have been, I think, fairly read. The objection is that your client had these reports for months, and he says, you know, if it come out yesterday, he might not even object, right? It's a question of notice.
I'm looking at the transcript at page 51. And Mr. Horn, and of course, Your Honor, my position is she's had plenty of time. It's not like this came out last week. In fact, it came out, it looks like April. She certainly had plenty of time to bring someone from DCF. That's a DCF, but it's unfairly prejudiced my ability to cross-examine. I might not even object to it if she just got it yesterday, if it just came out. But she's had this for months.
Yes, Your Honor. I think I read that objection more so to be someone from DCF is not here. And if that were the case, I don't know if that objection would have been made. But I think one important thing to note, and this wasn't in our briefs, and I think this does highlight where we kind of get to either an abuse of discretion or an error of law, is that, and directing the court to pages 70 through 71 or 72 of the record, you will notice that this is when JW was cross-examining MF. And one of the questions was based on statements that were not made in the DCF report. In fact, the question was, isn't it true that you didn't tell DCF a certain set of statements? We objected to that question. Trial counsel objected because this report was just excluded. That objection was overruled. So I'm having a hard time understanding how, assuming that the trial judge did exclude this because it was highly prejudicial, because it was surprising, how then is it possible that the trial judge allows JW to inquire on what is not in the statement if they are so surprised and they have no time to prepare anything in it? And I think that, to me, is where we go from an evidentiary issue, an evidentiary ruling that may be within the judge's discretion, and it becomes something that is a lot more problematic.
Right, but there's no offer of proof, right? She says, I did tell DCF that, and the question is, well, is there something in the report that would either, that impacts her credibility, that reflects she did or she didn't? At that point, there's an objection, it's sustained, there's no request to make an offer of proof or to say, you know, I understand you're excluding all of the records, but on this question, I'm asking to put in pages X through Z to show she did or didn't say it.
Yes, Your Honor. That would have been a better approach, but fortunately that didn't happen. And I think, though, the harm was still done there. The court let them use the report to impeach her. They let them use the report for the fact that something wasn't in there, but didn't let us use the report for what was in there. And I think
Rehabilitate her.
to either rehabilitate or to corroborate her testimony. And I think when you look at the court's decision, and I'm just going to jump briefly to our due process argument, one of which is that the court issued effectively a one-sentence decision that simply said, I don't find that she's established by a preponderance of the evidence the abuse that happened in 2015 through 2020, or the recent abuse. That is a decision that clearly indicates that he did not find the witness credible. That's how I read that decision. Now, again, putting aside that I don't think that affords this court enough information to discern why he arrived at that decision, there was evidence in those two reports that at least would have given some credence to her testimony, would have supported that testimony, and would have given him maybe some pause before saying, I'm going to completely discount what this person has testified to, which is in effect what the decision did. So I think, returning to the evidentiary argument, and I know my time is limited, so I want to just wrap up. I think it's really twofold. One is that we have this more flexible standard. We have this more flexible standard because there are things like DCF reports that have a lot of information in them, that have hearsay in them, that might have evidence in them that could unfairly prejudice a defendant. The court has the discretion to go through and determine what he does or doesn't want to consider. That is discretion.
But even if we agree with you that perhaps the judge ought to have considered this evidence, he heard from the witness. And I agree with you, made a credibility determination, didn't establish her burden of proof by a preponderance of the evidence. Because the double layers of hearsay and everything else and the fear of the prejudice, but you have the best evidence right here. You have the individual, the plaintiff, who's subject to cross-examination, and the judge's role is to make a credibility determination. Whether or not she told 10 people about this or no people, she's testifying right here before the judge. So Why is this reversible error?
This is reversible error because it was simply a failure to apply the standards of evidence that are applied in 209A hearings and similar hearings, which is a flexible standard where the notion is that if there is a reliability and if it is credible, which there's no argument, I would note on the record, that there was something in bad faith, there was something generated in bad faith about the DCF records, or something that was fundamentally unfair to JW, that evidence needs to be considered. And I would note just on yes, he did have the witness there. She did testify. The DCF reports contain statements from other people, her children, namely, who recounted some of the things that she testified to. And I would hope that a judge would want to take that into account when determining that this witness who has testified to these things is not credible, that their children are also not credible, that other people who heard these things, who might have witnessed these things, are not credible. I think not including those, and notably not even really apprehending what these reports contained, which I think from the record, it looks like the trial court thought they were about visitation rights. That was something that the trial court stated. That is not all that they were about. They concluded statements that would have corroborated her reasonable fear of imminent harm. And that is what the judge is tasked with doing.
But the only evidence of recent threats is her testimony that his current wife told her that he wanted to kill her, right? Is that correct?
That's correct, Your Honor. And, Your Honor, my time has expired.
You can address Attorney
The
Justice
DCF
Shin's question.
reports contain the same type of hearsay, but nothing else that corroborates the hearsay that I forget her initials, that she was testifying to, right? It's all hearsay.
If I understand your question, Your Honor, it's that the DCF reports included interviews of the children. It included interviews of school administrators.
Did it include interviews of the wife?
Yes.
Okay.
Also, interview of the wife.
We'll have to leave it there.
Yes.
For your co-counsel.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, as my co-counsel, Attorney Piercy, mentioned, my name is Savar Arguello, also representing the appellant and plaintiff below, MF. We do recognize that it is rather uncommon to have the panel hear argument on procedural motions. However, there were a few issues that we felt it was important to address that do come up in the motion to strike, just insofar as they might impact the scope of the factual record before this Court in rendering its decision. In particular, there are several factual assertions that appear in the opening statement of facts in our opening brief that opposing counsel seems to take issue with. In particular, first is the inclusion of the excluded DCF 51B report and the Family Action Plan as part of the record appendix. The basis for that objection in the motion to strike appears to be that because these pieces of evidence were excluded at the hearing, that they should not have been included in the appendix for the record on appeal. This is just simply not true. In fact, the record appendix clearly shows in the transcript where the items were marked for identification, specifically with comments from the trial judge that this was to preserve them for the appellate record. There's not much additional to say about that, except for that they were properly included, and because they form a central basis for our appellate argument, they are properly considerable.
I'm going to interrupt for a moment. I'm not in disagreement that in order to claim an abuse of discretion, you've got to present this evidence about what the judge didn't consider, right? But there's also a way to do it, right? And one of them is to say, the facts before the trial judge were X, but we attempted to introduce the following facts and said, The first thing out the gate in your memo, and I can see where this would cause someone to sit up straight in their chair, JW's repeated rape and sexual abuse of MF as a statement of facts, right?
Certainly.
Wasn't before the trial judge, in part because the trial judge didn't look at a bunch of evidence. But there is a way, when preparing a written appellate argument, to separate those two, isn't there?
Certainly, and certainly in our opening statement of facts, we could have been clearer that the facts that were being cited from the record appendix were those that were elicited from the testimony of MF, and could have been clearer about that. However, the actual citations to the record go directly to the testimony that was given, and so to the extent that there was any confusion about what we were asserting as the facts, I think that falls further into the strenuous advocacy territory and not in asserting facts that are not properly in the record. There was record citations for every one of the factual assertions regarding the sexual assaults that MF has claimed occurred during 2011 and between 2011 and 2015. And I don't see an articulation in the motion to strike of how it was unduly prejudicial or impacted this court's ability to parse through the distinction between what was testified to and what may or may not have actually been true. And for those reasons, there does not seem to be a proper basis to strike those statements from the opening brief or to strike the brief as a whole.
We're going to have to leave it there. Thank you.
Thank you.
Attorney Thomason?
Please, the court, Danielle Thomason representing JW. I think when we're looking at the DCF records, the biggest issue that we have is that they were given to the council from MF, that they were not business records. They were not an authenticated.
But under Frazado, they could have come in, right? If that was the only issue, is that they weren't certified pursuant to the statute. Judge could have considered them, given them whatever weight he deemed appropriate. They could have come in.
I think the issue was that we had received them, I believe, that morning. We hadn't seen them at the hearing in July.
So that actually is my question. I know we had two different hearings with two different judges. For the first hearing, the DCF records had not come up, had not been presented, had not been offered.
That's correct,
The
Your Honor.
first time, and he had the same lawyer at both hearings?
Yes, I was the attorney there.
Okay, and so at the second hearing, before the second judge, which is the order at issue here, that's when the
same lawyer.
DCF records come up for the first time?
That is when they came up for the first time. And if you look at what
And how much time, I forget, I can look it up, but the dates between the two
30
hearings?
days. It was July 28th, I believe it was July 31st till August 28th were the two different dates of the hearings. And if you look at the first hearing, so as for the records, not just the business record, but there were, if I recall, that when we received the records, there's a lot of redactions in them. They're not even a complete set of records. There's pieces of them. So different parties get different pieces of record. The other thing that we didn't get to do a lot of our objections based on, we were, once the decision was made, we didn't need to continue. But the other thing is, one of the more important things about that DCF record, and that we do state throughout our case, is that this has been a false narrative created by two women, and that this DCF record dates after when all of these allegations even began. That we have the argument that these came in 23. This woman was alleging that her fear started from a 2011-2015 assault.
Yeah, but that argument almost cuts against you, doesn't it? That's no unfair surprise. It's like, well, we knew this all along, that these two women were making this up. So if the judge could consider the 51B, but because of timeliness, you say that you got it just that day of the hearing or the day before?
Well, the day, I believe that I received it that day. I believe Ernie Hearn as well. But the other thing is, they weren't even accurate records, and I do believe that there's a spot in which MF states that there's errors in the records, and I don't think that
they were very minor. They didn't go to the substance of the allegations. They were about particular, was it an address or something of that nature, or something that she herself said they were just minor.
Well, the address also is improperly placed, because when you look at the way in which it was written discussed, the address was not discussed in the court as is stated in their brief. They stated that completely wrong, that I had asked counsel.
Right, but that's not really before us right now, right? I'm having a hard time here. Besides the whole issue of a half a hearing that just kind of gets disappeared, not your fault, and certainly not plaintiff's fault. But when we talk about due process and a fair opportunity to be heard, I don't even see on the record that the plaintiff, although I don't see that she objected, rested. So this is a new hearing. There's going to be 10 witnesses to be called, but I understand that in some ways the judge cut you off more than cut off the plaintiff, but I didn't see anywhere where the plaintiff said, I'm resting and I'm ready for argument.
She did. There's a lot of, that transcript also, I'm not sure exactly how they ended up with that transcript. That was a transcript that our client had just ordered because he's ordering transcripts from cases that I believe that counsel reached out to her and had it sent over. There's a lot of errors in there. She did rest her case. I didn't see
it in the
sorry,
transcript.
in the first instance she did. Second one.
That's
yes.
A nullity.
Great.
Right? That we started again, brand new.
Correct.
And I didn't see where the plaintiff rested.
Neither one had the opportunity. I also think that the judges do have the discretion when they feel that they've had enough information and evidence that they can say that they have completed. There were no other witnesses that were at the courthouse. There were no other witnesses that were being called on our side or on their side. That's the things that had been discussed prior to going in. Also, our objection both times that we did not want to go forward with an interpreter that was on Zoom, and it was an insistence of MF that not be continued based on the interpreter. She was the one that would not have been prejudiced because she would have continued to have her protection order. But both times we went there, we wanted that interpreter in person. And we were denied that by the
Separate and
plaintiff.
apart from the interpreter, and sorry to interrupt, but we have such limited time here. When it comes to, she testifies, is subject to cross-examination, don't her attorneys have an opportunity to rehabilitate the witness if there are particular issues that should be clarified?
I think that if you look at the manner to begin with, that she would have been able to maybe have been able to rehabilitate her, but she never even got on her direct examination, on her testimony, anything that even articulated any of the standards of the 209A. She didn't articulate a fear of her safety, of her harm, of imminent fear of her safety and harm. She didn't articulate that at the first hearing. She didn't articulate that at the second hearing. So regardless of the things that we asked her, which were really going against her credibility, which is a huge issue in this case, on both cases, that to just have rehabilitated her on her credibility, they still did not provide anything that would have met the standards of a 209A.
Well, they have an affidavit, right? Signed under the pains and penalties of perjury. They have a police report in which she says from 2011 to 2015, she was repeatedly raped. That was introduced, correct?
That was marked, that was identified, yes, Your Honor. And
that was introduced as an exhibit?
Yes.
Correct? Okay.
Yes. Again, after that.
Just letting you know, preponderance of the evidence, an affidavit coupled with a police report that says these things, and then she testifies.
The police report itself also was, and you're looking at that she's stating that something happened in 2011 and 2015 based on, and then bringing evidence in that all the documents that were created that she tried to produce were documents that were created and produced after after the allegations that are there. She's stating that she had been sexually assaulted, which is completely denied by my client. Each and every one of those documents that is coming in is so prejudicial against him and created after the events that she states happened. She also had the opportunity after the first hearing to have known, because about the witnesses that she could have brought in, or to have, she had a civil rights attorney that had more than enough time. There were a lot more DCF records also than those. So those were selected pieces.
So if you didn't cross-examine, and she presented the evidence that she did, and you rested, you went to argument, I can see your argument saying, she didn't present enough evidence. This doesn't meet preponderance of the evidence. But you attacked her credibility in cross-examination, right?
We did. So
she has no opportunity through counsel to rehabilitate?
She may have, but we didn't have the opportunity to finish either, because one of the things that we had and that we were prepared for, we kept being limited on our time based on the actions of MF. He's prejudiced at this point that he's had to hire counsel and go in time after time. We went in the first time. They hadn't timely gotten the interpreter. They hadn't timely had it on the Zoom. We dealt with that. We moved it again.
Okay, but
Circumstances.
you won.
I'm sorry?
You won, right?
But if you look at, she rested her case the very first time, and we were told that that's where she was going to.
Doesn't matter. It's a new hearing.
It was a new hearing, but I believe that.
So the old hearing doesn't get put into the calculus.
But even.
And so you attacked her credibility on cross-examination. You didn't say, no questions of this witness. Let me argue the case if plaintiff is resting. You attacked her credibility, and then she was left without an opportunity to rehabilitate herself. Am I reading that wrong?
I don't think that anything on which she had testified to that rehabilitation would have fixed it. We were talking about her taking the children off to Japan. She answered that question. Even if her attorney had gotten up and say, is it true that you don't want to take your children to Japan? Because that was a big issue in 2015. And what this court doesn't see is that she had testified at a trial. She had testified at depositions. All of these things had predated her restraining order that she had come in for. There was a lot of evidence that she had already testified to, but her stating, yes, I think I could take the children, I'm not sure whether that's still any of our attack on her credibility led up to anything that she still could have articulated at that point on cross-exam, on redirect. Where would they have cleaned up to create her fear of imminent safety and harm based on what her affidavit states and based on what she was testifying to? So the credibility issue, I think.
But the DCF records may have rehabilitated her.
I don't think the DCF records.
As to whether or not she disclosed the alleged rapes to DCF.
The DCF records, there were a lot of problems within those records themselves as well. And there were a lot of other records. So that's her portion of the 51A and B. The 51A and B, when it's given to a party, it's only given their portion of it. It's not given the entirety of that report. There's a lot that's redacted. So I think that had the DCF records, had we had knowledge that this was something that was going to be brought in, and they were dated November, they started back in November with different 51As and Bs that were going on. I think that had it been as a whole, I think that that would have given us a lot more to attack her credibility on.
But
unfortunately,
all would have been well and good if you didn't open the door on page 71. You indicate that Mr. Wexler, that the husband allegedly said to the kids that he wanted you to be kidnapped, raped, murdered, and left on the side of the road. You stated that in your affidavit, and you state that under oath today. Is that correct? Yes. Could you please explain why you never told to the DCF when you were interviewed? Don't you open the door?
I don't think that was even in, I don't even know if that was in the DCF records. We didn't have time to read what they gave us while we were there. So it was, unfortunately, Your Honor, I'm not unfortunate, but I have a lot more information when I'm there. So I know that I've spoken with DCF. We've had them in the probate court. We've had other opportunities to have the different knowledge of what was actually discussed and disclosed to DCF. That had not come out in the November, December, January, February, March, April. I think it was a significant amount of time before any of that was then reported to DCF. The stories kept changing on both sides throughout the entirety of the DCF record. So that was just selective pieces of that record.
Can I just remind you, the next time that you file a brief, your statement of facts do not have any record citations either.
My apologies, and what I will say is, first one, sitting here has been a great lesson, and I already had received a lecture with someone that I went through all of that. So it's a learning experience, and you won't see that again. Any other questions?
I don't see any other questions. We're happy to take the rest of your arguments on your brief.
Thank you, Your Honor.
Thank you all. The case is now under advisement. We're going to take a brief recess because we are switching to a hybrid hearing, and I want to make sure that our technology works. So as soon as we're ready, my assistant chief will let us know, but we are in a very brief recess.
You can't even...